Is it harder for a woman to be a prosecutor, particularly in a murder case, or do they have some advantages? Let's talk about that. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. Linda Stermer is on trial for the second time for the murder of her husband after her first conviction was reversed. The state alleges she doused him with gasoline and set him on fire. Her story is he was smoking dope and burned himself up. The state alleges further that after escaping the house inferno, she ran him over with a van. However, the cause of death is fire and smoke, not vehicular trauma. The state says she keeps changing her story. Her photos after her conviction was reversed show a dark haired woman. Her presence in the courtroom now shows a white haired woman. Is she trying to get sympathy, perhaps? Stay tuned. We're in the Linda Stermer murder trial up in Michigan, and the opening statements occurred yesterday, along with some evidence. And one of the things that I found rather interesting is that the elected prosecutor is actually the person trying the case, and she's a female, and she's prosecuting another female. Now, as a general rule, strategically, whenever we had a female defendant on trial, we liked to have a female lawyer with us sitting at the counsel table. In fact, we usually liked for that person to take the lead, particularly when it came to questioning the witness, because many times when it comes to women questioning women, they tend to ask the right questions. There is just something there. It's not some kind of magic or mojo. It's just, I think, a familiarity with the way people think. And I don't want to group women into one, big homogenous mess, but there are certain ways that women think that are different than men. I think everybody recognizes that. And as a result, it is a good idea to have a woman take the lead in questioning a woman. We do that with female witnesses and we do that with female defendants. There is no attempt to try and cabin them as to just dealing with women. It's simply something that I think is a good idea, again, because that's another way for people to develop expertise. You can sit there and watch somebody else do it and take notes, and you can learn a lot. In fact, as I started out, I learned a lot about questioning witnesses, oftentimes from my wife, who would ask me later on, "Why didn't you ask that?" Like, well, it never occurred to me. So, again, just an observation here for what it's worth. In addition to that, it's nice if you have a female question a female so that it doesn't look like the lawyer is jumping up there, big bad lawyer in that big bad suit, and he's browbeating that witness. You don't want that because that engenders sympathy for the jury gets sympathetic toward the defendant at that point, and that's not a good idea. Well, all of those things play into a criminal trial too. You don't want the jury feeling sorry for the defendant who's on trial. Sure, she lost her husband, but in this case, the allegations are that she killed him. So it's sort of like the kid who, killed both of his parents and then threw himself on the mercy of the court because he was an orphan. It's not a good idea to challenge that narrative without having some appreciation for what's going on in the background. So I was really impressed by the fact that the elected prosecutor was doing the prosecution because usually elected prosecutors are just administrators. Now, that's true in big cities and it's true in big counties, other places. But I imagine up in Michigan, they actually have working lawyers who are running as prosecutors and doing the actual trial work in important cases. And so it was good to see that that's where they went at the beginning. Now, I thought her opening statement was a pretty good opening statement. I have a couple of clips here for you. The first one we're going to look at is her talking about checking off the boxes of the elements for first degree murder. Let's watch.
Thank you very much for being here. I know that you probably know, I think prior from the judge, who I am, but my name is Susan Zeiderveen, and I'm proud and honored to represent the state of Michigan and the people of Van Buren County as your elected prosecuting attorney. So now is the time for opening statements. It's our opportunity to tell you what to look for in the case, kind of our roadmap, what we plan to present to you over the course of the next several days, what evidence that we plan to present, and who will be testifying. So we talked a lot about in voir dire, about the charges and the elements. So I want to take a few minutes just to dive into what those elements are and what the charges are. We have count 1, first-degree murder, and we have count 2, felony murder. So what are the elements that we talked about that I need to prove to you? So for count 1, the very first element, the first box that we need to check, is that the defendant caused the death of Todd Stermer. That is, that Todd Stermer died as a result of the actions of the defendant. That's the first box. Second box, that the defendant intended to kill Todd Stermer. That's the second element. Third, that this intent to kill was premeditated. That is, thought out beforehand. And the last box, last element that I need to check on this count, is that the killing was deliberate, which means the defendant considered the pros and cons of the killing and thought about and chose her actions before she did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It's for you to decide if enough time passed under the circumstances of the case. And the killing cannot be the result of a sudden impulse without thought or reflection. Those are the 4 elements, the 4 boxes.
She did something that I think is very good here in that she talked about checking off the boxes like you would on a form, because there might be people on the jury that are note takers. And then she also talked about the boxes, putting the stuff in the boxes. Boxes are a nice metaphor for where all the evidence goes. You know, the evidence of, for example, premeditation. Well, that's this item and this item and this item, and they're in this box. So at the end of the trial, you pull out the boxes again and you say, okay, remember the elements? One of them was premeditation. All right, let's go through the elements that we proved. That's a very handy thing to do, and it looks like that's sort of what she's setting up here.
When they drive up, deputies locate several people standing on the north side of the residence. For those of you that are directionally challenged like I am, that's if you're looking at the front of the house, it'd be to the right, to right of that picture. At this time, they locate Todd Stermer. He's laying in a pool of blood, approximately 20 to 25 yards from that side of that residence. Mr. Stermer this says unclothed. It's actually not 100% unclothed. His sweatpants and his underwear are pulled down to his ankles. He doesn't have a shirt on, and he's still wearing his socks. He is badly burned, and to say badly burned is an understatement. His burns cover almost all of his body. His hair is gone. His ears are deformed. His skin is slipping off his body. Due to his injuries, the people who are on scene try to move him farther from the home, just to be able to get him away from the fire and away from the house, and then they attempt to render aid.
I really like the way this prosecutor talked about the injuries, not because they were graphic. I mean, you certainly can have your own imagination as to what that must have looked like, and that's probably all you want to have is your imagination. But if you get too graphic in these cases, a lot of times that turns off juries too. So she talked about what the facts were, and then she moved on. She didn't spend a lot of time dwelling on it. And I think if she had, she probably would have drawn an objection. But that was fairly well done. Next, she talks about one of the other witnesses in the case and what he's going to testify about with respect to the cause of death.
You will hear from Dr. Markey at Sparrow Hospital, who conducted the autopsy. You will hear his cause of death is from those burns.
So, if the cause of death is the fire and the burns, the the fact that he was run over by a vehicle is a very bad thing. I mean, certainly you wouldn't want to have that, but it doesn't mean that it has any bearing whatsoever on the actual fact of whether she caused his death. Because the only way the state is going to get to causing the death is to prove that she set the fire. And I think the way they have to do that is with some of her statements.
You will also hear that on January 9th and 10th, James Shinsky is hired by the defendant's insurance company to conduct an investigation, their own investigation into the fire. He has a background as a fire investigator. He then does recorded interviews of Linda Stermer, with Linda Stermer, on January 9th and January 10th. You're going to start hearing, as people start digging in to the questions, start asking more questions, start going into the things that don't make sense, the explanations that the defendant starts giving, and how the story grows and changes. It's going to start here.
Now, one of the things that we see a lot in the plaintiff's bar is, particularly with new lawyers, they want to prove everything. In other words, if, for example, in a medical negligence case, you have a doctor who made a wrong diagnosis and it wound up killing somebody, in addition to that wrong diagnosis, they're going to take pot shots at the amount of time that it took the doctor to do his evaluation, or they may take pot shots at the fact that he has a prior DUI conviction, or any number of things that are not directly related to the issue at hand. In other words, instead of focusing on the negligent act in a civil trial, they focus on all the other bad person inferences that can be drawn from all these other things. And if you do that too much, you're going to wind up losing the verdict. The verdict is going to be reversed because you're proving a bunch of stuff that you have absolutely no need to prove. And also, in many cases, the judge is going to go, oh, no, we're not letting that in. That's stupid. It doesn't relate to what's going on here. So, one of the ways that you can signal that your case is somewhat weak is to go down a rabbit hole you don't need to go down. And in this case, the rabbit hole is the van, hitting him with the van. Now, I would agree that it does look rather suspicious if you're trying to rescue your husband, as she apparently claimed at some point, that you inadvertently wind up running him over, or perhaps advertently running him over. It does sort of lend some degree of inference to the fact that she was trying to get rid of the old boy. But it also can be explained by panic and by smoke. There's smoke in the air. She's panicked. She says she's trying to get him help. Who wouldn't be trying to help their husband? I mean, even if you didn't like the guy, you would probably be trying to get him help because he's badly burned. She obviously knows that. She saw him come out in flames. As a result of that, when you go down the rabbit hole of pushing this toward the issue of him being run over, you are you're not illustrating for the jury how starting the fire and the fire itself was the cause of death. So the other way that, of course, they can get a conviction here is through felony murder. And I suppose running somebody over with a car is a felony. And as a result of that, they could say that there is a linkage there, but the cause of death is the smoke and the burns. And that happened inside the house, not outside the house. And if I were the defense attorney, I would immediately object at any mention of the van because I would say has nothing to do with the cause of death, Your Honor. They haven't established any linkage, and as a result, all that can possibly do is confuse the jury. And even if I didn't win that argument on the evidence, I would preserve an appellate issue that I could assert again later on.
Particularly important are the statements about running Todd Stermer over with the van. Statements about never seeing the defendant. Statements about why. Why would you drive to the back of the house on a walkout basement? Why? You'll hear them.
So, this was really the only thing I saw in this opening statement that I thought she might have done better. I think it would have been perfectly appropriate to present some evidence or say that you're going to present some evidence on this, but to underplay it rather than say it is particularly important, because it's not particularly important in the grand scheme of things. It's only particularly important because it adds more fuel to the fire.
At the end of this trial, ladies and gentlemen, all the boxes that we painstakingly went through in the beginning of this opening statement will be checked. And I am going to ask all of you to render a guilty verdict on counts 1 and count 2. Thank you very much.
A couple of other observations I'll just throw in for good measure. First of all, although you might look at this young lady and think she's kind of mousy, she certainly isn't timid. She certainly knows her case, and she's a very clear communicator. I think that she has the advantage in this trial simply because she's working for the state. As I've always said, the state gets a lot more leeways from the judge, gets a lot more room to maneuver, and the defense, not always the case. I just think that the opening statement was a good opening statement, but for that mention, that rather sad mention of running him over with the car. It may not make sense. It may be part of the grand scheme of things that doesn't make sense in this case, but it's not directly relevant on the fire, and that's where they got to get her if they're going to get her. So that's what I have for you today. Boy, I sure am glad to be back, and I'm also glad I've got a job where I get to sit. So hopefully you guys have a terrific day. Catch me down here at the beach again tomorrow. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.